Hi guys, welcome to another episode of the IFBF podcast. I'm PJ Patterson, the chairman of the IFBF, and I'd like to introduce the guest for this podcast. Her name is Marie Brownell, and I had the pleasure of interviewing her recently to discuss wills and estate planning. This is a topic that I think brokers need to be informed on because we deal with such an important and large transaction in a person's life, and it has a potential impact on their estate planning. So I think it's great for us to, as a broking community, to learn how to have this conversation with our clients about wills and estate planning. And this particular podcast, or this interview rather, that I did with Marie will be absolutely fantastic to give you a bit of knowledge and understanding on that topic. So enjoy.
But just before we get started, I just wanted to run through quickly so you guys kind of know what I'm up to with my business. Just a little bit about a charity organization I'm supporting, which is called B1G1. If this will work, there we go. B1G1 is just a business social enterprise that is making high impact around the world by giving to various projects, 100% of which the funds that I give to them go to those projects. So I, as a business, now as a social enterprise, am supporting B1G1 and a number of projects that they have. These guys are headquartered in Singapore, really cool bunch of people. If you're interested, go check out their website. I think all businesses should be looking at aligning themselves with something like this for their business because it makes a big difference, I think, when you have the ability to say to your clients that I'm doing this sort of stuff. But just briefly, what they actually do, so there you go, I'm proud to be part of the global social enterprise called B1G1. They're actually aligned to the United Nations 17 Sustainable Development Goals. And this is a project that was kicked off by Richard Branson, and the name of the guy escapes me, but he's the CEO of Unilever. They all came together at the United Nations and they came up with these Sustainable Development Goals. B1G1 itself is what's called a funded platform. So I, as a business, give them, not give them, but support them with their staff. So I subscribe to their service basically and pay for their staff. So all the money that I give through my business goes 100% to whatever project I support. And this is really about making an impact for people around the world, not so much about giving money. And as I said earlier, I think people now are awakening to the fact that they want to do business with businesses that are actually making an impact in the world. There's your 17 Sustainable Development Goals. That's a pretty cool slide. I like all the colors and stuff. I'll just pause for a second and let you have a look at that. But there's some really, really cool, powerful initiatives that they're all looking to change the world in a number of these areas, or transform the world, I should say. I won't dwell on the Sustainable Development Goals, but there's a number of things there that they're really trying to achieve. The final thing I'll just say is these are some of the projects I support. B1G1 has over 500 projects on their platform. These are a couple of projects I have supported in the past and continue to do so every month. And the point of all this is to say that I want to thank you all for being here today, and I am going to be giving, through the B1G1 platform, 7,500 days of clean water access to some families in Ethiopia or communities in Ethiopia to address that issue of water quality around the world. So thank you for bearing with me on that little spiel. If any of you are interested in learning more about the B1G1 website or platform and what they do, I am more than happy to have that conversation with you guys. So let's get on to the star of the show. Marie, are you still with me?
I am. I hope
okay, great. Can everyone now see the slides? Marie, do you see the estate planning slide now up?
Yes, I can. Thanks.
Fantastic. So guys, we're joined today by Marie Brownell from Equity Trustees. She is a senior estate planning solicitor there, accredited specialist in wills and estates. She's a lovely lady. We work closely together with my clientele. I pass pretty much all of my clients through to Equity Trustees to do their will and estate planning stuff. And Marie, thank you very much for joining us today to take us through this thing called estate planning.
Thank you, PJ. Yes, we're just going to kick off today by looking at, the difference between a will and an estate plan, and sort of try to debunk some of those myths and answer any questions that you might have. So let's kick it off.
Sounds good. Just tell me when you want the next slide. You want it now?
Yes.
Okay.
Okay, well, we've run through that and we'll go to the next one. So this is a pretty scary stat that exists in Australia, that over 40% of Australians don't have an appropriate or valid will. And when we talk about appropriate or valid, it means that they could have wills that are completely out of date. I often see clients who tell me that they made a will, 25 years ago or 20 years ago. And I often ask them, has anything happened in that last 5 years? And not one person has said, no, nothing's changed. Everyone's had changes in circumstances, yet not one of those people have gone to the trouble of changing the wills, and they've got, some pretty outdated things in their wills. Some of the common triggers that should prompt a change to a will, marriage, divorce, separation, birth of children, changes in the circumstances of your beneficiaries. If there's been a death in the family and someone that's mentioned in the will has passed away, it's also a time to think about updating the will, and also review every so often anyway, because laws, particularly taxation laws and just general laws when it comes to wills and estates, they do change over time. And there have been some significant changes in 20 years, and that should prompt people to, think about making a new will. The good thing is, when you do a will with equity trustees, we do remind you every few years about the importance of updating the will, and we will ask you, has anything changed in the last few years that might warrant a change to your will? So we're just going to move along to the next slide, which is, what's an estate and what forms part of an estate? And this is really critical when we're looking at wills. I think most people just think, well, everything I own just forms part of my estate, and if I have a will, then that will cover all those assets. And that's actually not the case. We all have a number of assets these days that don't automatically form part of the estate, and the will won't cover those assets. A common one's life insurance. Some people have life insurance held outside outside superannuation, and that life insurance might pass to a nominated beneficiary, or it might pass to the estate. I've had a client this week who has a $1.2 million life insurance policy, and she had nominated in that policy her parents some years ago. She's since married and has a young child. And when I asked her, is that who you still want those life insurance proceeds to go to if you died? She said, oh gosh, no, I want it to actually go to my husband to help look after him and my children. So, that had she died with that nomination in place, it wouldn't have gone as she had intended. It would have been paid to her parents. So looking at the nominations in life insurance is really important. Superannuation's a really big one. Most people these days have superannuation of some sort. Anyone that's worked over the last 20 years would have some sort of superannuation in superannuation account. And when you die, there's a compulsory cashing out event. It means that that superannuation death benefit has to be paid out. And again, superannuation doesn't just form part of the estate. The superannuation is a trust like any other trust. It's managed by a trustee, and the trustee determines how that superannuation death benefit is paid if there's no nomination in place. You can make a binding nomination. Most super funds will permit it, and you can nominate who you'd like your death benefit to be paid to in the event that you died. You can pay it to the estate, or you can nominate what we call superannuation dependents. And that's typically your spouse, your children of any age, or someone who had some sort of financial interdependency relationship with you at the time that you died. And in the absence of having any of those people in your life, the payment must be made to the estate. And obviously the estate will always consist of solely owned assets. So, shares that you might have in your own name, property, bank accounts, anything that's personally owned by you will form part of your estate. Some people also have what we call family trusts, And once again, the assets in that trust don't form part of the estate when you die. And when we have clients who have family trusts, we look at how do we pass on control of that family trust. You know, we look at who would continue to be a trustee of that trust. We look at who might be the appointer of the trust. And if it's our client, we consider some of the ways in which they can pass that really critical appointer role onto their intended beneficiaries. Jointly held assets is also another asset that doesn't form part of the estate. If you own assets jointly with someone else, on the death of the first joint owner, the asset automatically passes to the other joint owners, and it doesn't form part of the estate of the first person to die. So there are a number of assets there that might be common to you, or you might, have some of these assets and you might think, well, geez, my will doesn't cover all those assets. And when you do your estate plan, we look at how those assets can be passed on to your intended beneficiaries. So PJ, do you want to go on to the next slide? So any estate plan has a will. The will's a critical part to the estate plan. And basically a will is a written document which appoints an executor. It gives assets and money personally to intended beneficiaries. It nominates guardians if there are minor children. It contains trustee powers. So it enables the trustees, gives powers to enable the trustees to manage and deal with the assets in the estate, and also assist the beneficiaries as well. It's critical that a will is executed formally and properly and in accordance with the law. At the moment, wills need to be signed, dated by the will maker in the presence of 2 independent witnesses. So that's witnesses or people that aren't included in the will. An estate plan obviously has a will, because that's, as we said, a really critical part to the estate plan, because they will deal with the estate assets. But it also involves a full review of the estate and non-estate assets. So all those assets that we just mentioned previously, life insurance, super, family trusts, joint tenancies, we look at all those assets and then we work out how do we transfer or deal with those assets when our client passes away. An estate plan enables wealth to be transferred on death from one generation to the next in the most tax-effective manner. So we look at ways in which we can mitigate the taxes that might be payable on death, and how we can minimise the tax position of the beneficiaries when they do inherit the assets that they've received. So we also consider the needs and circumstances of the beneficiaries. Every beneficiary is different. There are different strategies that we put in place depending on the needs and circumstances of beneficiaries. If we've got beneficiaries that are vulnerable, or they might be in financial risk, or they might be in the clutches of a divorce or a relationship breakdown, there are certain things that we can put in place to protect the inheritance that they receive and mitigate the risk of those assets, perhaps going to the trustee in bankruptcy or going to the ex-spouse. We identify risks and challenges to the estate. This is particularly the case where there might be people, and this usually crops up where there might be estranged children in a relationship. Clients may not have seen their children for some time, or there's been some event that's taken place that's meant that relationship's now fractured, and they don't want to include that child in the will. Well, that child does have the ability to make a claim in the estate and challenge the will and ask the court to consider whether a claim ought to be made for them. And we look at those risks and we work out, to what extent that risk is a real one for the estate. And we put in place strategies to reduce those risks and reduce the costs of that litigation taking place. We talk about the right executor for the estate. The role of the executor is really critical. The executor basically steps into your shoes when you die. They deal with all the assets. They sort out all the taxes. They pay out or they distribute the estate in accordance with the will. Now, having that appointment, not having the right person in that role, sometimes means the estate gets off to a really bad start. And it's very hard to come back from that. You might have an executor who just can't be bothered dealing with the asset. You might have one or two executors that just can't get along, and they're just not able to put those differences aside and just get on with the job of managing the estate. There's many different types of issues that can crop up with having the wrong executor in the role. Dealing with death is obviously a really critical part of wills and estate plans, but we also need to think about what would happen if you lose capacity. You know, so you're still alive and your will won't come into effect till after you've died, but you want to make sure that if you do lose capacity, that you've chosen the right person to make financial and personal decisions on your behalf. So putting in place what we call powers of attorney or appointments of enduring guardian enables you to choose when that person would be able to act for you, and also who's going to be acting for you. We can also put conditions and limitations in those documents, and we can set out directions around how your attorneys or your enduring guardians should be making decisions if they're managing your affairs due to your incapacity. We might flick over to the next slide, PJ. So, as mentioned, when we're doing an estate plan, we obviously put the will in place, and we do a lot of other things to make sure that all your assets are dealt with. And that might be putting in place superannuation death benefit nominations, so to make sure that those death benefits are paid out the way you intend. Putting in place powers of attorney and appointments of enduring guardian to deal with incapacity. We'll review family trust deeds and look at those trustee and appointor roles and work out how best and how it's possible to transfer control of that structure to the people that you want stepping into that family trust. We obviously review superannuation trust deeds just to work out if there's any impediments to us making binding death benefit nominations, or if there's anything in that deed that sets out how those benefits are to be paid. For those people that have shares in private companies, we look at how the company's constituted by reviewing the constitution, and also working out what sort of rights the shareholders have, and who's going to continue to be a director of that company when our client dies or becomes incapacitated as well. But for those people that are running businesses, shareholder, unit holder and partnership agreements need to be reviewed to work out how that business succession is going to occur on the death or incapacity of a client. And, obviously working out if there's any life insurance attached to those business succession plans, and considering, what the estate will look like when the shareholder, unit holder or the partner passes away. And looking at binding financial agreements as well, some clients will enter into, what we call a binding financial agreement, or what's known in the socially as a prenup. If you want to reduce the risk of your assets being involved in a property settlement, if there is a relationship breakdown, a binding financial agreement will assist with that. And we'll review those agreements to just see if there's any issues around what happens on death of a party to the relationship, if that agreement sort of sets out what assets will or will not form part of an estate. So that's pretty much our estate planning in a nutshell. And we just wanted to introduce to you the various concepts and issues that are relevant for an estate plan, and the difference between just doing a will and having a proper estate plan. And I'm happy to take questions now.
Cool. So guys, if you have questions, and thank you, Marie, for doing that very, sort of in-depth, high-level presentation of estate planning versus wills. I will kick off with a couple of questions. if I may, I wanted to ask you, you mentioned something, actually, let's go right back to almost the beginning. Equity trustees, for those who don't know what Equity Trustees actually does, can you just explain how you guys fit into being a valuable referral partner for doing wills and estate planning for clients? Can you just explain that so everyone is clear on that?
So Equity Trustees it's a trustee company, and we deal with core traditional trustee services, and that's managing private wealth as well as corporate wealth and also superannuation. In our private client space, which we call Trustee and Wealth Services, we do a lot of work around managing estates as an executor. We manage trusts as a trustee. We act as attorneys for people that are either out, overseas and they have assets here, or they've lost capacity. We also do estate planning services, which is the team that I work in. So we cover the life cycle of people. So we plan the estate. We can act as an executor. We can act as a trustee, and we can also act as the attorney for someone who's lost capacity or requires attorney services.
Cool. Thank you for that. I do have a question that's come in regarding costs. We'll come back to that, Michael, if that's okay, because I wanted to just dwell on a point with you for a moment, Marie, about the executor services. And I've been at presentations before where, lawyers are talking about the role of the executor, and you did touch on it there in your presentation. And I've met people who've been executors of wills who basically say, never, ever, ever again will I be an executor of a will. And I think it's worth mentioning or just maybe explaining the responsibility that an executor has, and maybe why you would use a service or a company like Equity Trustees to actually fulfill that role in an estate. Can you just elaborate on that?
Yeah, look, acting as an executor is quite a laborious task. So there's a lot of work involved in it, and there's a lot of legal work that also gets involved. That is part of the process. So initially, if you're the appointed executor, your role kicks off with identifying and locating the will, working out whether there's any particular instructions around the burial or cremation of the body, and attending to that. So the executor's role is to organise the funeral. The executor also then needs to work out what all the assets and liabilities of the estate are, and that can be as simple as going through a client's personal details and personal papers at their home, or contacting their accountant or their financial planner and getting an idea of all the assets that person owns. Once you've identified all those assets, you then also have to work out what liabilities there are, and you need to work out the quantum of those liabilities and work out whether those liabilities are indeed payable. Once you've done all that, you then also need to work out if there are any outstanding tax liabilities payable by the deceased and also by the estate. I had a client in on Monday whose partner's just died, and he hadn't filed his tax returns for the last 10 years.
Oh, no.
And she has been given the joyous task of sorting out his taxation affairs, and it's estimated that he owes the tax office approximately $80,000. So she's a bit upset about that, but she's having to go and find all that paperwork and deal with the accountant and attend to all those taxes. Once she's finalised his tax returns, she'll then have to work out the tax returns for the estate. Once you've sort of worked out all the liabilities and attended to the taxes and the like, getting probate's obviously the next major priority. And depending on what the assets are, you might have to get probate in New South Wales if the assets are here. If there are assets in other jurisdictions, you might have to deal with with the government authorities in those jurisdictions to deal with those assets too. Once you've got probate, you then need to collect all those assets. So transfer all the assets from the deceased to the executor, open bank accounts in the estate's name, pay out all the liabilities, and then make the distributions in accordance with the will. That might be as simple as just, paying out the remainder estate, but it might be as complicated as, finding all those personal assets that are specifically mentioned in a will and then arranging for those beneficiaries to come and, take those assets from you and receipt those assets. Or it might be shipping those assets to various beneficiaries wherever they might be. But it is and obviously your role is to distribute the estate in accordance with the will. Where you fail to do that, you can be personally liable for an incorrect distribution, or a distribution that you haven't made, or if you haven't paid out a liability, you might also be personally liable to the creditor for that payment. If you don't attend to the tax returns of the estate and the deceased, you will be personally liable to the taxation office for non-payment. So we've got a job that requires a lot of tedious administrative work attached to it, with a lot of legal liability if you get it wrong.
Sounds like it. And I'm glad you went through that very thorough explanation of it, because I don't know why anyone would actually want to be an executor of a will, given what you just said. That's a pretty serious work, and it's obviously also some pretty serious liability if you get it wrong. Can an executor, just like if I was the executor of someone's will, could I actually charge for that service, or would I not be able, or recover expenses for time spent on it?
So you can recover your actual expenses. So anything that you've actually incurred, you can recover. However, you can't claim money for your pains and troubles unless the court authorises that payment, or the beneficiaries of the estate authorise that payment, or the will itself includes a payment to the executor. So we often ask our clients where they have appointed someone who's not getting a benefit in the will as the executor, would you like to leave a cash gift to that person for their pains and troubles in acting as the executor of the estate? In the absence of that provision, and in the absence of the beneficiaries agreeing to give someone some money, then that executor needs to go off to court and make an application to the court for the court to determine what would be a reasonable commission payable to that executor for their pains and troubles.
Yes, once again, sounds like a job that no one would want to do. Now, Steve has just asked a question about how long is an executor valid for? I presume they're valid unless they're removed.
So the role of the executor kicks in when someone's died, but it stays in effect until the estate's been, properly administered. The problem that you can sometimes get, and we've had this a few times being a trustee company, we may have administered an estate, 50 years ago, and there might have been an asset that was not picked up at the time, or we weren't aware of. And then suddenly, all these years later, that asset becomes known, and that executor then has to step back in and deal with that asset. So theoretically, it should only be for the period of time it takes to administer an estate. So that might be, 6 months, 12 months, a year, 2 years. If there's any litigation in the estate, so if someone's challenged the will, then the executor has to defend the will and take part in those proceedings. So if that happens, you're in the role until all that litigation's resolved and the estate's properly administered and finalised. But you can be brought back in if sometime down the track some asset becomes known that wasn't dealt with at the time. So it could be, for a short period of time, or, you could be brought back into it many, many years later. But generally speaking, it could be 1 or 2 years.
Okay. Once again, I asked the question, why would you bother being an executor? Well, let's move on to something else. I've got another question for you. And guys, I did see your questions come in regarding costs. We'll cover those sort of at the end, and Marie can maybe address that for you guys. But we've had this conversation before, Marie, about whether an Australian will applies in a foreign jurisdiction and vice versa. So if someone, say, was a New Zealand resident, lived in Australia for their life, had a will in New Zealand, would that will apply here? And then the opposite of that as well. So could you just talk to that for a second?
Yeah, look, foreign assets in foreign jurisdictions is a really tricky area of law. So for countries that are part of Her Majesty's Dominion, which is Australia, New Zealand, the UK and the like, we have an arrangement where if you have a valid will in New South Wales, for example, or in New Zealand, then that will can be then probated in another jurisdiction. So if you had a will made in New Zealand and there are also assets in New South Wales, if that will is proved and probated in New Zealand, that will can then be resealed in New South Wales, and it's kind of just getting probate of that will in New South Wales, and then that gives the executor the ability to deal with the assets in New South Wales. The problem, though, that comes up is that every jurisdiction has their own revenue and taxation regime. And what can happen is, although we have a means of enabling an executor to deal with assets in other jurisdictions, there might be inadvertent tax consequences. And without proper estate planning, you might trigger what we call an inheritance tax that might affect the worldwide estate. So we generally recommend that where people have assets in other jurisdictions, that you have a will dealing with those assets in that jurisdiction, just to quarantine the assets there. So A, we overcome any tax issues. B, each estate can be administered simultaneously rather than waiting for one estate to be dealt with in one jurisdiction and then dealing with the estate in the other jurisdiction, because they'll have to happen not concurrently. You'll have to deal with one, then the next one, then the next one.
Mm-hmm.
And the other problem also is that not every country in the world recognises wills. Some countries, there's no ability to make a will. So we might produce an Australian will in that country and they'll say that's great, but we don't recognise that will. And that will is not going to be sufficient to deal with the assets here.
So it sounds like the moral of that story is if you're in doubt, maybe with your assets in a particular country, maybe just have a will in that specific country dealing with the assets in that country. Would that be the best way to address it?
Yeah, to the extent that you can do that.
Yeah. Okay. Cool. Because I know a lot of I have clients that have assets all over the world, and certainly people that will be watching this webinar are going to be dealing potentially with clients that have assets in different parts of the world. So it might enable them to have a conversation with them about their estate planning and where they're up to. So that's cool. I wanted to ask a question about joint assets. When you mentioned in your slide there with all the different types of assets, a joint asset. So this would be an asset that I own with someone that is not a spouse. Mm-hmm. Is that right? When you refer to a joint asset?
Yeah, it could be a joint asset that you own with anyone. It might be a case that you don't particularly want the spouse to automatically get that property anyway because you've got children from another relationship. Mm-hmm. And you might think, well, I really want to preserve my interest in that property so that I can pass that on to the children, but I still want my spouse to have the use and the benefit of enjoying the property. So if we have a joint tenancy or a jointly held asset, and we don't want that asset automatically passing to the other joint owner, we can do what is called a severance of that joint tenancy. Mm-hmm. And we can create actual ownership parts of the property. And when we do that, we create what's called a tenancy in common. And we set out who owns what parts. And those parts are capable of forming part of the estate. So part of the estate plan will look at what exactly that joint tenancy looks like, whether we want that asset passing automatically to that particular person, or do we want to sever that joint tenancy so that we can bring part of that ownership into the estate.
Okay. That's good to know. Because I've seen you guys make some changes or suggested changes to titling and stuff with some of my clients, and I guess that would have been around that sort of scenario where they maybe didn't want the asset to automatically go to that person if
That's
they died. Okay.
Mm.
I wanted to ask another question about businesses. So you also mentioned business assets and those sorts of things that people have, and again, a lot of the folks that will be watching this webinar will potentially have a number of small business clients or business clients. Can you just elaborate on the importance of actually dealing with those business assets correctly, and maybe the best way to do that, ensuring that you've got maybe a buy-sell agreement or some other additional documentation than just your will and what should be part of the estate plan for that business?
Yeah, look, each business is unique in the way they've structured their business. It might be a family trust, it might be a private company, it might be a partnership, it might be a unit trust. There's so many ways in which you can operate and run a business. The problem that usually crops up with a lot of business owners is, where there's, more than, there might be two families involved, or it might be mum, dad, and the kids, or dad and all the sons involved in the business. The big concern that arises is, well, what happens when one of those business owners dies? And, where you do have private companies, or you've got some sort of unit trust or share structure, what potentially can happen is the wife or the spouse or the family members of the deceased business owner has the ability to step into that business. Now, for the other business owners, that can be a real problem, because suddenly they're dealing with a whole other group of people that might not have any idea of what the business is involved in. They might not have the business acumen to be involved in that business. It can just slow down and cause issues with the continuing administration of the business. So lots of business owners should consider putting in place what we call a buy-sell agreement or a business succession plan. Now, a buy-sell agreement basically says that when a business partner needs to exit the business, that however they own their interest in the business, that automatically gets transferred to the other business owners. And there's usually some arrangement around how that exiting business owner's interest is valued and how that payment is going to occur. And how it's going to be funded is the other critical part. So most people will have something in place that says, if I die, there's a life insurance policy that just gets paid to my estate for the value of my share of the business, and then the other business partners will then just acquire my interest in that business. Or it might be a case that the other business partners need to fund a payment to the estate of the deceased business owner, so that they can continue to manage that business themselves without having other people involved in it. But often it's something that's overlooked, and there's lots of particular issues that crop up. Every business is different, every structure is different. So from an estate planning perspective, we need to look at a lot of issues around those sorts of businesses, and what estate planning implications there might be if our client, one of those business owners, dies. And it's not just death, it's also incapacity. If you lose capacity, you're obviously not going to be able to run the business. So what happens in that situation, which is another really critical element to business succession planning.
Yeah, I think it's a critical element to estate planning in general. Can you just maybe elaborate on that just for a moment? The incapacity, because we call those in the U.S., we call those living wills. And I think you mentioned they're called enduring guardianships here. Is that correct?
It's a power of attorney. Well, we've got powers of attorney to deal with financial and legal affairs. And then we've got what we call guardianship to deal with someone making decisions about your health and lifestyle. Mm-hmm. So when it comes to business succession planning, it would be around having a powers of attorney in place. Mm-hmm. When we're looking at someone deciding what sort of healthcare you receive if you lost capacity, we're looking at, a guardianship appointment in that case. And that guardianship appointment might say, if there's no likelihood of me recovering, I really don't want any artificial life-sustaining measures put in place, and I would like to be left comfortable, but have the ability to just to die and not have your life artificially sustained.
And is that sort of document something that is stock standard with any estate plan that you guys put together? I mean, do you include that in the package, as it were?
Yes, we do. So our package, so to speak, will include wills, powers of attorney, appointments of enduring guardian, and looking at if there's superannuation, we'll look at the super. If it's we'll look at all those assets and put in place the mechanisms to enable those assets to be dealt with on death.
Okay. And I mean, just for everyone's benefit, I suppose this is one of the reasons that I chose to partner with you guys, because I would get a lot of people saying, "Oh, I'll just go to my local solicitor and they'll do a will for me." And I say, "Well, send me the will," and it's like 3 pages long, and I'm like, "This isn't this is not an estate plan. This is just a very basic document. You need something more robust." And I think that's super important for everyone to understand, that an estate plan encompasses all of those things you just mentioned. It's not just about having a will. It's about dealing with and looking into the future and addressing things that may or may not happen. Is that a fair statement?
Yeah, it is a fair statement. And looking at the circumstance of the beneficiaries is a really critical part to it. Your basics 3-page will isn't really going to be able to cover off on your beneficiary issues. We might need to set up testamentary trusts in the will because of the circumstances of the beneficiaries. So, we'll look at structuring around making sure those beneficiaries are protected in the best way possible, depending on what their situation is. So we can talk to you about any issues that you might have or concerns that you have around your beneficiaries, and putting those details in the will so that they're covered off and those beneficiaries are getting getting the inheritance that they're getting in the best way possible.
Awesome. Now that sounds really good. And I think, just to refresh on the circumstances or the things that would trigger off a review of a will. Now, one of the key things you mentioned is that if a will has not been updated for, say, the last 10 or 20 years, that's probably a big trigger event, because I think legislation and laws do get updated and changed that require will language to be amended.
Yes, lots of things have changed. I won't go through all of them, but there's now a 30-day survivorship that applies to a beneficiary that wasn't around 20 years ago. The power of attorney documents have changed in the last 20 years. We've had a change to the power of attorney legislation in the last 20 years. We've had so many changes to legislation, and where you do have these documents that were prepared many years ago, they might still be valid, but it's not, those documents aren't really reflecting what the current legislative requirements are. And you could be missing out on opportunities that you didn't know you had because you've got these outdated documents.
And of course, the biggies, as you mentioned, marriage, divorce, even a separation probably could trigger off a review. Obviously, if you have children or any major change in circumstance, like taking out a mortgage or maybe selling a business asset, something like that, those would all qualify as a reason to review the will.
Yeah. And I just want to point, with the separation and divorce, if you separate, that is a very critical review or trigger point in looking at your estate plan. We have so many clients that will come in and say, "Oh yes, I'm separated from my spouse. We sorted out all our property things many years ago, and here's my will that we made when we first got married."
Mm-hmm.
And you think, well, it's great that you've gone to all the trouble of sorting out your personal and property matters, but the will that you have still leaves whatever you own to your spouse.
Mm-hmm. Mm-hmm.
Separation has not revoked that divorce, has not revoked those provisions. So if you died with that current will in place, the former spouse, I use the word, wasn't the separated spouse, will still get your estate via the will. So it's really critical that if you separate, that you update your will. Ideally, you'd get a divorce at the same time. For some reason, people out there seem reluctant to do that final piece of having the divorce, but they'll get around to sorting out custody and property matters, but for some reason never get the divorce. If that's you, you need to update your will and powers of attorney and all those other documents very quickly, because it could end up with the former spouse.
Yeah, I think that is a very critical point that does often get overlooked. I've heard of cases where that exact sort of thing happened, especially in blended families and people who want certain assets to go to, children of previous marriages, all of that sort of stuff. Very, very, tricky area of estate planning, I would say. We got about 10 more minutes, so I just will hit a couple of the questions that have come through. So just to follow on from that executor question we had earlier, Steve elaborated and said that he had just signed up to be the executor for a close friend. And so I guess my question to you, Marie, on behalf of Steve would be, can he revoke that in light of what he's just learned today? Can he say to that person, look, sorry, but maybe you should take up a service instead of me taking on this responsibility?
Look, absolutely. Hopefully, it sounds like he's been asked if he wants to take on the role. If he's rethinking it, he could certainly go back to his friend and say, look, I've thought about it and I'm not sure if I'm the right person for the role. The other thing that also can happen after someone's died is you can, as an executor, what we call renounce the role. So you don't, even though you've been appointed the executor, you don't have to take on the role at the time. You might have been willing to do it now, but someone might not die for 20 years. And at that point you might think, oh gosh, I'm at a different point in my life and there's no way I could possibly take on this role. So there's nothing to stop you from renouncing that role before you actually start doing the role. And that's the critical point. You have a window of opportunity to decide whether or not the role's for you. If it's not, then you need to renounce very quickly. And hopefully in the will it sets out who's to act as the substitute executor. When we draft a will, if someone says, oh, I'd like to appoint my spouse, so we'll put the spouse down and we'll ask, well, what if your spouse can't do it for any reason? Who would you like to appoint? So we can have a series of substitutes. Most people will have equity in there as a substitute or as what we call a backstop. Yes. And that just enables people to know that if they don't, or the executors to know that, well, look, if I can't do it, at least we know there's a professional eventually that'll be able to step in and manage the role. And that gives some executors some comfort in knowing that even if they don't take on the role, the estate's still in good hands and still capable of being managed.
And I suppose that the follow-up to that is if an executor was appointed and maybe that executor died and there was no other provision in the will, would the court then decide who the executor is and appoint one?
Yeah, so the role then becomes an administrator and the court appoints the administrator for the estate. So where there's an absence or for whatever reason no executor is capable of acting, either because they've predeceased, there's no substitute, or the appointment's just invalid for some reason, you do have to go through a process of having an administrator appointed, and the court has to approve the person that's put their hand up to act as the administrator.
Okay. Now that's good to know that at least that fallback, the court will appoint that. Well, we're about on time, and I really appreciate all the wonderful value that you've given us today, Marie. And I suppose it's only fitting that you should communicate to our audience the service that Equity Trustees provides, and maybe just a little bit around the costings for a single or joint will as at the date we're recording this, which is the 31st of October.
So we're really happy to offer a fixed fee service. So unlike other solicitors out there who do a lot of estate planning work, they generally charge on an hourly rate, and it might be a few $100s an hour, and on average it's about it can take up to about 10-20 hours depending on how complex it is. It can be many hours involved in doing the estate plan. So where you go to other solicitors, they will charge on a time spent basis, and it can be, thousands and thousands of dollars. We do offer a fixed fee service, and our fixed fee service covers the will, the preparation of the wills, the powers of attorney, and appointment of enduring guardian. And it must also include making the binding nomination. But generally that's what's included. And again, it's a fixed fee service. It includes meeting with you, taking your instructions, talking to you about the strategy and the concerns that you might have for your beneficiaries. And it also includes obviously meeting with you again to get the documents signed and making sure those documents are executed properly. We do prepare drafts of all of our documents for you to review so that you can let us know whether any changes need to be made. So it's a process that's very inclusive, and it's, there is a lot of toing and froing between us and the client just to make sure those documents that we prepare are, right on the money and you're comfortable with what we've put in place. And for a couple, the fee's $2,420, and that includes GST. And for a single person, it's $1,950. The other benefit is that we will come to you if you can't come to the city. We are based in Sydney, but we do have offices around Australia as well. But if you're a New South Wales-based client and you can't make it to Sydney, we can make arrangements to still assist you with your estate plan, and we might come to you as well and get your estate planning documents in order. So it does include that travel too.
That's great. A solicitor firm that makes house calls. I love it. I love it. Well, Marie, we're just about on time. Does anyone else have any questions? I think we've touched on everything that you guys have dropped in the chat box. So I'll just give it another couple of moments for any additional questions.
PJ, the other thing that we can do is make available to your clients or those that attended our presentation our fees, but also what we call the executor toolkit, which does set out the various process and what's involved in the administration of an estate. So that gives a really good overview of all the various elements and issues. And we can send that to you as a PDF, and you can email that to those who are interested in receiving the information. Perfect.
Thank you very much. Well, I'll definitely take you up on that offer and get that sent out to all of the people that attended the webinar. We don't have any other questions coming in. So Marie, Brownell, I will thank you very much for joining us today on this webinar and giving us all of that tremendous value. That was killer. I learned something. I learned something every time I talk to you, I think, but I definitely learned a few things today. So thank you very much again for your time, and thank you everyone for joining us.
Right. Thank you, PJ.
Cheers. Bye-bye, everyone.
Bye.